Labor and business law foundations. Labor law and business law are fundamental pillars of any business environment, defining the relationships between businesses and employees, and the broader legal framework for operations. Labor law specifically governs employer-employee interactions, focusing on rights and responsibilities, while business law covers a wider array of legal principles. Understanding both branches is crucial for entrepreneurs, business owners, and managers to operate legally, avoid potential lawsuits, and ensure fair treatment of all stakeholders. For instance, a small business owner must understand labor laws when hiring staff and business laws when entering into supply contracts. The scope of business law is vast, encompassing areas like contracts, property rights, commercial transactions, and the formation of business entities. Labor law, conversely, is more specialized, dealing with human resource management and worker protection. Labor law, employee protection. Labor law is vital for human resource management, protecting workers from exploitation and ensuring safe, fair working conditions, including regulations on working hours, minimum wage, and benefits. Employment contracts are a core element, outlining job responsibilities, compensation, and the duration of employment. Legislation also covers collective bargaining, union rights, and dispute resolution. For example, the Fair Labor Standards Act, FLSA, in the United States sets federal minimum wage, overtime pay, and child labor standards, ensuring fair compensation for millions of workers. OSHA, the Occupational Safety and Health Act, mandates that employers provide a safe working environment. This includes specific regulations for industries like construction and manufacturing, where hazards are more prevalent, significantly reducing workplace injuries and fatalities over decades. Business law, transactions and contracts. Business law is a broad field governing all business operations, including transactions, partnerships, and contracts, providing a legal and ethical structure. It ensures fair treatment for all parties and protects the business from legal liabilities. Contract law is a primary component, with contracts serving as foundational tools to formalize agreements between two or more parties. These agreements outline terms, obligations, and legal consequences for non-fulfillment, covering everything from purchasing goods to providing services. For example, a contract for the supply of goods specifies price, quantity, delivery schedules, and payment terms. Breaching such a contract can lead to severe financial consequences, including lawsuits, underscoring the need for clear and enforceable agreements. Intersections and compliance importance. The intersection of labor law and business law is evident in employment agreements and corporate governance, requiring businesses to comply with both when hiring and managing employees. This ensures employee rights are met and legal obligations regarding compensation and working conditions are upheld. A real-life example is Google's 2017 settlement with the U.S. Department of Labor, addressing concerns over equal pay and discriminatory hiring practices. This case highlighted the necessity for companies to comply with both labor and business law to ensure fair treatment and avoid legal violations. Incorporating business law into a business plan is crucial for considering all legal aspects, including legal structure, contract types, and regulatory compliance. This proactive approach helps manage mergers, acquisitions, consumer protection, and environmental regulations, safeguarding assets like intellectual property. Child labor, a global ethical issue. Child labor is a persistent global issue, exploiting children by depriving them of their childhood, education, and potential. It arises from economic necessity in developing countries and exploitative business practices elsewhere. The consequences are devastating for children and society, impacting long-term development and perpetuating cycles of poverty. Globally, an estimated 160 million children are engaged in child labor, with nearly half in hazardous work. Businesses must understand the legal, ethical, and practical aspects of child labor to operate responsibly and comply with international labor standards, especially within global supply chains when multinational companies are often held accountable for supplier practices. ILO definition and industry prevalence. The International Labour Organization, ILO, defines child labor as work that is mentally, physically, socially, or morally dangerous or harmful to children. This includes work that interferes with a child's schooling, either by preventing attendance or forcing premature withdrawal. Child labor is most prevalent in industries such as agriculture, manufacturing, mining, and domestic service. In these sectors, children often work long hours in hazardous conditions for little or no pay, facing risks like exposure to harmful chemicals or physical injury. While some work, like household chores or assisting in family businesses, is not considered child labor, any work negatively impacting a child's development or future prospects is deemed exploitative. For example, children in mining operations often suffer from respiratory diseases due to dust inhalation. Root causes and exploitation examples. Poverty is a primary driver of child labor, as families often rely on children's income for basic needs like food, clothing, and shelter. In many developing countries, children are viewed as economic assets, making their labor a means to improve family finances. The demand for cheap labor in certain industries also drives exploitation, as children can be paid less and are less likely to demand better working conditions. This creates a perverse incentive for businesses to employ them. A notable example is the cocoa industry in West Africa, particularly in Côte d'Ivoire and Ghana, where numerous reports detail children forced to work on cocoa farms under hazardous conditions. These children are exposed to harmful chemicals, long hours, and physical abuse, highlighting severe exploitation. International frameworks and business responsibility. International organizations have developed conventions and guidelines to eliminate child labor, with the United Nations Convention on the Rights of the Child, CRC, being a significant framework. Adopted in 1989, the CRC is the most widely ratified international human rights treaty, outlining children's rights, including protection from economic exploitation. The ILO established the Minimum Age Convention No. 138 in 1973, setting the minimum employment age at 15 years, and the Worst Forms of Child Labor Convention No. 182 in 1999, which calls for immediate prohibition of severe forms like slavery and hazardous work. These conventions provide a global standard for businesses. For businesses, understanding these legal requirements and ethical considerations is essential for maintaining a good reputation and avoiding legal and financial repercussions. Companies found in violation can face significant fines, legal actions, and severe reputational damage, impacting consumer trust and market share. Contract law. Business foundation. Contract law is a fundamental aspect of business law, forming the core of every business transaction by defining relationships, rights, and obligations between parties. It provides the legal framework for interactions, whether for partnerships, supplier agreements, or employment. Understanding contract law is essential for business owners and managers to operate within legal boundaries, protect their interests, and avoid costly disputes. A well-drafted contract ensures clear terms and provides mechanisms for enforcement if disputes arise. Contracts serve a wide range of business purposes, including the sale of goods, provision of services, financing, and employment. They are the bedrock upon which commercial relationships are built, ensuring predictability and accountability. Essential elements of a valid contract. For a contract to be legally binding and enforceable, it must meet several essential elements. These include an offer, acceptance, consideration, the intention to create legal relations, and the capacity of the parties. An offer is a clear proposal by one party to another, stating terms for willingness to be bound, while acceptance occurs when the second party unequivocally agrees to those terms. For example, a vendor offering a product at a specific price is an offer, and a customer agreeing to buy it is acceptance. Consideration involves the exchange of something of value, such as money, goods, or services, between parties. The intention to create legal relations presumes both parties intend the contract to be legally enforceable, and parties must have legal capacity, meaning they are of sound mind and legal age. Without these elements, a contract may not be enforceable. Types of contracts and examples. Contract law distinguishes between various types of contracts commonly used in business. A unilateral contract involves one party making a promise in exchange for the performance of an act by another, such as a reward offer for finding a lost item. Conversely, a bilateral contract is an agreement where both parties exchange promises, like most sales or service agreements where both commit to specific actions. For example, a software development contract where the developer promises code and the client promises payment is bilateral. Contracts can also be express with clearly stated and agreed upon terms, or implied, formed by the parties' actions or conduct without formal agreement. An example of an implied contract is ordering a meal at a restaurant, where the agreement to pay and serve is understood. Breach of contract and international assets. A breach of contract occurs when one party fails to perform their obligations, such as not delivering goods, delivering non-conforming goods, or failing to pay on time. The non-breaching party has the right to seek remedies. Common remedies include damages, monetary compensation for losses, specific performance, a court order to fulfill obligations, or contract termination. For instance, if a supplier fails to meet a critical deadline, the buyer might seek damages for lost revenue. In the global business environment, international contract law is crucial, requiring businesses to navigate complexities across borders. International contracts often include choice of law and dispute resolution clauses, specifying which country's laws govern and how disputes are resolved, often through international arbitration. This helps mitigate risks in cross-border transactions. Recruitment process and strategy. Recruitment and contracting are critical for business growth, forming the foundation of employer-employee relationships and defining roles, responsibilities, and expectations. A robust strategy attracts the right talent and ensures legal compliance. The recruitment process involves several key stages: job analysis, sourcing candidates, screening applicants, interviewing, and final selection. Job analysis is the initial step, outlining responsibilities, skills, and experience to create precise job descriptions. Sourcing candidates utilizes various channels like job boards, recruitment agencies, social media, and referrals to build a diverse applicant pool. Screening involves reviewing resumes and qualifications, while interviews assess technical skills, cultural fit, and past behavior. The final selection often includes reference and background checks. Employment contracts and terms. Once a candidate is selected, the employment relationship is formalized through a contract, a legal agreement outlining terms and conditions like job duties, salary, benefits, and working hours. This contract safeguards both parties by ensuring clarity and mutual understanding. While employment contracts can be verbal, written agreements are generally preferred as they provide a formal record, crucial for dispute resolution. In most jurisdictions, key elements like job title, responsibilities, compensation, vacation, benefits, and termination procedures must be included for validity. Contracts define the working relationship, distinguishing between permanent, fixed-term, part-time, and temporary roles. For example, a full-time contract establishes clear expectations for consistent hours and benefits, whereas a fixed-term contract specifies a duration common in project-based industries. Contractor agreements and legal risks. Contracting arrangements extend beyond individual employment to include agreements with external contractors or consultants, often for specialized services not requiring full-time commitment. These are governed by service agreements, outlining scope of work, payment terms, and deadlines. A key distinction between employees and independent contractors is the level of control a business has over the worker. Contractors typically have more autonomy and are responsible for their own taxes and benefits. Employment contracts fall under labor laws, while service agreements are under commercial contract law, offering greater flexibility. While contracting offers flexibility and scalability, misclassifying employees as independent contractors carries significant legal risks, including penalties for unpaid benefits or taxes. Businesses must carefully review service agreements to ensure compliance with labor laws, especially in jurisdictions with strict worker rights regulations. Law of sale, goods and ownership. The law of sale governs transactions of goods and services between buyers and sellers, being a fundamental aspect of business law crucial for modern commerce. It applies to everything from retail consumer goods to complex industrial machinery contracts. Understanding its principles ensures transactions are legally binding, fair, and enforceable, protecting both buyers' and sellers' interests. The law of sale primarily deals with the transfer of ownership in goods for a price. Goods encompass all movable property, including physical items like electronics and vehicles, as well as intangible property, such as intellectual property rights. A contract of sale is formed when a seller makes an offer to sell goods and the buyer accepts it, agreeing to the price. Key elements and title transfer. For a sale to be valid, mutual agreement between parties is essential, achieved through a specific offer from the seller and unequivocal acceptance from the buyer. The offer must clearly outline terms like goods, price, and delivery. Consideration, where each party provides something of value, for example, money for goods, is also crucial. Once accepted, the contract binds both parties to their obligations. For example, in a car purchase, the buyer's payment is consideration for the seller's car. A key aspect is the transfer of ownership, the legal right to possess and control goods, distinct from physical possession. Ownership transfer timing depends on contract terms, sometimes immediately upon sale, other times upon full payment or delivery. Title, the legal evidence of ownership, is critical. If a seller lacks valid title, for example, selling stolen goods, the buyer may not receive valid title and can seek remedies like contract rescission and compensation. Delivery, warranties, and remedies. The law of sale also covers the delivery of goods, which is the process of transferring physical possession from seller to buyer. Contract terms typically specify the time, place, and manner of delivery, such as requiring delivery to a specific location or pickup from the seller's premises. If the seller fails to deliver as agreed, the buyer may seek remedies like contract cancellation or damages for incurred losses. If goods are damaged or non-conforming upon delivery, the buyer can reject them and seek a refund or replacement. The law also protects buyers if goods are lost or destroyed before delivery, often entitling them to a refund. A critical element is the warranty of quality, implying goods meet certain standards. Express warranties are specific promises, for example, a manufacturer's defect-free guarantee, while implied warranties, like merchantability, ensure goods are fit for ordinary purposes. If goods fail these warranties, buyers can return them, request repair replacement, or seek compensation. Another implied warranty is fitness for a particular purpose, meaning goods are suitable for a specific use communicated by the buyer. Lease agreements, landlord and tenant. The law of lease governs the relationship between a landlord, lessor, and a tenant, lessee, in real property rental arrangements, providing a legal framework for property use and enjoyment. It addresses rights, obligations, terms, rent, maintenance, and termination. Understanding lease law is essential for both parties to ensure smooth agreements and avoid disputes. A lease agreement is a contract where the landlord grants the tenant property use for a specified period in exchange for periodic rent payments. Key elements include identifying parties, describing the property, address, square footage, amenities, lease term, short term like 1 year, or long term spanning decades, and rent payment terms. While oral leases exist, written leases are preferred for clear evidence and dispute resolution. Residential leases often have more consumer protections than commercial leases, which are typically more negotiable. Lease terms, disputes, and termination. Rent is a crucial lease aspect, typically paid monthly, with the lease outlining the amount, due date, and payment method. Provisions for rent escalation, example with inflation, and late fees are common. Failure to pay rent can lead to significant consequences, including eviction or legal action. Maintenance and repair responsibilities are critical. Landlords typically ensure habitability and compliance with building codes, while tenants maintain cleanliness and perform minor repairs. Clear clarification of these obligations prevents disputes. Some jurisdictions have rent control regulations, limiting how much landlords can increase rent annually. The law of lease also addresses subletting. Tenant rents part or property while retaining responsibility and assignment. Tenant transfers entire lease interest to a third party, often requiring landlord approval. Common issues include non-payment of rent, leading to eviction, a legal process involving notice and a period to remedy the breach. Disputes are ideally resolved through negotiation or mediation, but legal action may be pursued. The concept of quiet enjoyment ensures the tenant's right to use the property without interference. Leases can terminate by mutual agreement, expiration, or breach, with break clauses allowing early termination under specific conditions. Agency law, principal and agent. The law of agency governs relationships where one party, the agent, is authorized to act on behalf of another, the principal, to create legal relationships with third parties. This is fundamental in business, as companies rely on agents for contracts, transactions, and representation. Understanding agency principles is crucial for businesses and individuals to ensure legal soundness and protect rights and obligations. An agency relationship is established when a principal appoints an agent, and the agent agrees to undertake specified duties. Agency relationships can be created through express agreements, written or oral contracts, implied agreements arising from actions, or by necessity in emergencies to protect the principal's interests. For example, a real estate agent acting for a seller is an express agency, while a company allowing an employee to routinely sign minor contracts might imply agency. Agent duties, authority, and liability. An agent's authority can be actual, explicitly given, or implied as necessary for duties, apparent when a third party reasonably believes the agent has authority based on the principal's actions, or implied, necessary to carry out express duties. For instance, a company's sales manager has implied authority to negotiate prices within certain limits. Agents owe several duties to the principal: loyalty, acting in the principal's best interests, avoiding conflicts; care, acting with competence and diligence; and acting within the scope of authority. Breaching these, especially the fiduciary duty of loyalty, can lead to liability for damages. The principal, in turn, must compensate the agent, provide necessary resources and support, and indemnify the agent for expenses or losses incurred while acting within authority and good faith. A key legal issue is liability. If an agent acts within authority, the principal is bound. If the agent exceeds authority, they may be personally liable, and the principal may not be bound. Agents can also be liable to third parties for fraudulent or negligent actions. Governance, accountability, and transparency. Business governance and legal compliance are integral to corporate operations, ensuring organizations function within legal boundaries while maintaining ethical standards. Governance refers to structures, processes, and mechanisms guiding decision-making and accountability. Effective governance builds credibility, fosters stakeholder trust, and promotes long-term sustainability. A fundamental principle is accountability, where management is answerable for actions, with mechanisms for transparency and oversight. In large publicly traded companies, the board of directors oversees executives and strategic decisions, holding them accountable. Shareholders, in turn, hold the board accountable through voting rights and demands for performance. Good governance also emphasizes separation of powers to prevent unchecked control, with clear roles for the board and management, often including audit and ethics committees. Legal compliance and ethical business. Legal compliance is the process by which businesses adhere to all relevant laws, regulations, and industry standards, covering areas like environmental regulations, labor laws, intellectual property rights, consumer protection, and tax laws. It is crucial for avoiding legal penalties, reputational damage, and operational disruptions. Non-compliance can lead to severe fines and legal action, while compliance ensures ethical operations, fair employee treatment, and positive community contributions. Achieving compliance requires thorough understanding of the regulatory landscape and implementing compliance programs with policies, procedures, and training. For example, in healthcare, companies must comply with HIPAA for patient privacy, involving employee training, data security audits, and breach protocols. Compliance officers or departments monitor adherence, identify risks, and implement preventive measures. Corporate social responsibility, CSR, bridges governance and compliance with ethics, involving voluntary actions like environmental sustainability or fair labor practices, even when not legally mandated, to strengthen reputation and foster customer loyalty. Environmental law and sustainability. Environmental law is a critical aspect of business operations, regulating human activities' impact on the environment to ensure sustainable, environmentally friendly, and responsible practices. Growing concerns about climate change, pollution, and resource depletion drive increasing environmental regulations. Compliance is vital not only for legal reasons but also for long-term business success, reputation, and viability. Environmental law encompasses air and water quality, waste management, hazardous materials, energy efficiency, biodiversity, and land use. Businesses in manufacturing, energy, and agriculture face regulations on emissions, waste disposal, and resource use. Laws like the Clean Air Act, CAA, and Clean Water Act, CWA, set pollutant limits, while the Resource Conservation and Recovery Act, RCRA, governs hazardous waste. Environmental impact assessments, EIAs, evaluate potential environmental effects of projects, ensuring mitigation strategies are developed. Climate change regulations, such as the Paris Agreement and carbon pricing, incentivize businesses to reduce their carbon footprint and invest in renewable energy, demonstrating leadership in sustainability. Intellectual property and copyright protection. Intellectual property, IP, and copyright law are essential components of business law that safeguard intangible assets, fostering innovation, fair competition, and protecting creative works. IP covers patents, trademarks, trade secrets, and copyrights, each protecting different forms of intellectual creations. Patents grant exclusive rights to inventors for typically 20 years to use, sell, or license their inventions, preventing others from unauthorized use. Trademarks protect distinctive signs, symbols, words, or logos that identify goods or services, preventing confusingly similar marks. Trade secrets protect confidential business information, formulas, processes through non-disclosure agreements, unlike patents or trademarks which are registered. Copyright law specifically protects original works of authorship, literature, music, films, software, architectural designs, granting creators exclusive rights to reproduce, distribute, display, and perform their works, typically for the life of the author plus 70 years.